Here, good morning, good afternoon, and good evening to all participants, so where and which location you are. So welcome to the Berlin Center for Consumer Policies online panel on regulatory challenges in digital markets. So my name is Isabel De Silva. I am an associate professor of economics at ESMT Berlin, and I have the pleasure to moderate today's panel discussion on the Digital Markets Act. So this is the EU legislative proposal to regulate digital markets. We have 5 distinguished speakers, as Thomas already mentioned, who will provide their expert opinions on the topics that we cover today. First, let me introduce you our distinguished panelists. I start with Cristina Cafara, Dr. Cristina Cafara. She's an expert in competition economics. I'm sure you have seen her in many different panels already. She led for several years the antitrust and regulatory team at Charles River Associates in Europe. She has directed economic analysis in multiple competition investigations on some of the landmark mergers and antitrust matters of the past 20 years, both in front of the European Commission and the competition agencies of UK and multiple member states and across the globe. She has provided expert economic evidence in multiple litigation cases before the courts and advised both corporate and government enforcers in multiple cases, digital companies, media, telecoms, and more. So it's great to have you here, Cristina. So I move on to first introduce again our next speaker, Isabel De Silva, who has been the president of the French Competition Authority since October 14, 2016. She's a member of the French Administrative Supreme Court, and in the past she served as an advisor to the Ministry of Culture and Communications. She was in charge of the press and the radio, director of legal affairs of the Ministry of Ecology and Sustainable Development, Transport and Housing, and became a member of the sector regulator for press distribution in 2012. It's great to have you here, Isabel. And next speaker, Professor Amelia Fletcher. She's a professor of competition policy at Norwich Business School and deputy director at the Center for Competition Policy. She's also she's at the same time a non-executive director of the Competition and Markets Authority. This is the antitrust authority in UK, a member of the enforcement decision panel of Ofgem, so the UK government regulator for gas and electricity markets. And she was recently a member of the AHM Treasury Commission Digital Competition Expert Panel, also known as the Furman Panel. This is the report published in March 2019. And she served as a non-executive director of the Financial Conduct Authority and Payment Systems Regulator in the past, and chief economist at the Office of Fair Trading. So it's great to have you here, Amelia, and I'm sure that most of our participants have seen you already in several different panels, but today I'm sure we will discuss different issues than they have already seen. We are discussing. And Professor Dr. Fiona Scott-Morton is the Theodore Nierenberg Professor of Economics at the Yale University School of Management. Her area of research is industrial organization with a particular focus on empirical studies of competition. Her current research focuses on competition in healthcare markets and economics of antitrust. And from 2011 to 12, she served as the Deputy Assistant Attorney General for Economic Analysis, Chief Economist at the Antitrust Division of the US Department of Justice, where she helped basically enforce the nation's antitrust law. It's great to have you here, Fiona. And Professor Dr. Monika Schnitzer, our final panelist, is a professor of economics at the University of Munich. Her research focuses on innovation, competition policy, and multinational corporations. For the past 20 years, she has been active in policy advice for German government and also European Commission, including vice chair of the Expert Commission on Research and Innovation, as a member of the Economic Advisory Group on Competition Policy of DG Competition. And since April 2020, she has been a member of the German Council of Economic Experts. It's great to have you here also, Monika. So after introduction of our great panelists, as you have already seen, they're all experts in the topic that we are going to cover. I want to briefly tell you the panel's focus today. We have 5 important topics from the Digital Markets Act. Again, this is the EU legislative proposal on regulation of digital markets. And after each topic discussion, we will have 10 minutes for topic-specific Q&A. And at the end, we will have 30 minutes open Q&A discussion. So what I would like to ask from the participants is type your questions whenever you want to the chat. We will be collecting those questions, and I will be reading them to the panelists during the appropriate Q&As. But please keep in mind that we have limited time, so we might not get to your question, so apologies for that in advance. So the first topic, we would like to start our panel by the introduction of the DMA report, its objectives and relation to existing competition policy enforcement rules. So I would like to ask Christina to start this discussion and what she thinks about as the objectives of the DMA report and how it relates to the competition policy enforcement rules. Christina, floor is yours.
Thank you so much, Özlem, and thank you to BCCP for this invitation. It's a pleasure to be here. Let me start with what I consider to be a religious practice, which is my disclosure. I have worked adverse to Google in multiple matters, never worked for or against Facebook. I have worked for Microsoft, for Apple, for Amazon, for Netflix, and for Uber. I'm always surprised that when I'm on a panel, although there are multiple people who should have something to disclose, they don't. So I feel very strongly that that needs to be the beginning of every discussion. So what I would like to do in the next perhaps 10 minutes is set the scene for the discussion that will follow and tee up what I think are important topics that the other panelists will develop further, but perhaps start with a bit of an arc of history. How did we get here? How did we get to a place in which we are now at a great big bend in the road, what I call the great pivot to regulation? And I think that I don't need to get over the diagnosis and what the problems are, because of course we have read several reports, many also by some of the other panelists here, Amelia, Fiona, and so on. And so we understand what the diagnosis is. Consumers are now, instead of thinking of being in a world of seamless switching and multi-homing, in fact funneled into a limited attention brokers, so hyper attention, with all the attending sort of consequences of that and the concerns that we have around that. So the diagnosis, I think, is quite settled at this point. Economies of scoping data, network effects, and so on. What I think is a reality that we need to confront, and this isn't about pointing fingers, it's a fact, antitrust has not really been very effective so far. And it is something that I know gives people pause, and I understand people who are in an institutional position need to, of course, defend the track record, but it is a fact that I think we haven't achieved very much, with few exceptions, in the work that we've done in antitrust. This is not about intentions, the quality of the work that was done. It is more about the fact that there are inherent reasons why antitrust in this space has got limitations. I'll go through them quickly, but I think it's important to unpack perhaps a few. One which is inherent and which is something we cannot do very much about is the fact that antitrust, by definition, because it looks at a problem at a time, is systematically missing the big picture, focusing on one issue at a time, and it is always yesterday's issue. Think about the arc of the enforcement against Google in the last decade. You've had the Commission starting off with great intention with shopping 10 years ago. In reality, with hindsight, we all know that comparison shopping isn't a particularly worthwhile industry that was important to somehow defend, to save the world from the search monopoly. It is the case that was there. And while the Commission diligently went along and did comparison shopping, then was Android, and Google was looking over there and saying, well, swing the monopoly to the mobile space, okay? Yeah, you stay busy with it. You stay busy with something else, and then you do Android, and the Commission says, oh, a monopoly, we need to do something there. And Google says, okay, let's kind of look at Android. Meanwhile, I'm going over here, I'm doing ad tech. Oh, and meanwhile, while you start looking at ad tech, I'm going to go over there and start looking at health tech and start looking at cars and IoT. So by definition, we are always 7 years behind the action in antitrust. There is a rumor today that the Commission has effectively said they might be opening a proceeding on AdTech at the end of this year. I mean, the case started in 2000. Everyone else has been there. How long do we need to do these cases? And we do need a lot of time for reasons that I'll discuss, but it is inherent in the process. One of the reasons we take a lot of time is that the whole process is grotesquely gamed by the defendants, grotesquely. For every RFI, you get a request for an extension of 6 months, 3 months, and so everything takes forever, inevitably. There's been a total vacuum of enforcement in mergers. I know this will be a topic we'll discuss later, but we need to just confront that reality. We haven't enforced in digital mergers at all. And that is a major problem because in this world, we're now trying to catch up, exposed, trying to undo the market power when we haven't enforced against mergers in the first place. There's a host of other reasons, briefly. There's some timidity of some regulators because there is an overwhelming fear of tackling the new, and I can see it. So this reluctance, Isabel is an exception, but there is a general reluctance to adopt theories of exploitation of data abuse because they are novel. And that is linked to the uncle tag of precedent. We do not want to go anywhere precedent hasn't gone because then we may lose in court. And then the last one is really fear of losing in court. If we lose in court, all hell breaks loose. The institution is demotivated. We cannot face that or confront that too much. So all of these reasons that play a part in the game in the enforcement of antitrust have collectively meant that with a great deal of work and good intentions, I think we are 10 years later not where we'd like to be because you look at the market share of Google in search, it has flatlined at 95%. Facebook hasn't been dented. Nothing has changed fundamentally. So I don't want to be pessimistic, but it is a fact that there is inherent difficulty in making the world change with antitrust, which is why now we are faced with this great big pivot to regulation, which is not just the DMA. The DMA, of course, is the subject of the discussion today, but there is a diffuse effort, which is global, to design regulation to bring big tech under control, and there is a lot of experimenting with different approaches. So we'll talk about the DMA, but I wanted to flag, and I'm sure will come up in the discussion. The UK has got its own regime, its own digital market unit. Germany, of course, amended the competition law. France is very active, and now we've got the US with this draft proposal. So there is a big pivot towards this approach. So I will briefly talk about the DMA and what I see as the main issues, and then we can dive deeper into it in the rest of the discussion. But then DMA, what are the key principles? Essentially, you have the designation of certain firms as gatekeepers. That is a common feature to other kinds of experiments. In Germany, you have what you call firms with paramount cross-market significance. In the UK, you have strategic market status firms. Everything starts with filtering certain firms as being the target of the regulation, right? So we call them gatekeepers. And then there is the identification of a set of rules that are supposed to capture the conduct that we're concerned about and that are supposed to apply ex ante. So as everybody should know at this point, there are 18 rules split between a blacklist, Article 5, a gray list, Article 6, where one is more per se, the other one is kind of capable of being more nuanced. And so I think the issues that this throws out for discussion, the topics that I think we should explore in the rest of this discussion that I want to tee up, because they are the ones that I think are interesting and important and open in this. One, certainly the designation of gatekeepers is a major issue. I personally think it shouldn't be so major because we know who you are. So, I mean, I don't think we are going to just, at least from my perspective, or should spend so many calories kind of scratching our heads and think, who might this be? There is a sort of limited number of people who should be. And to me, that shouldn't even be something appealable. We know who you are. Let's just not waste time. Number two, is there a set of rules as it is crafted now well crafted. And this is not a philosophical question. It's not about semantics, and it's not about adding an adjective here and there. It is about ultimately whether they're capable of self-execution, which is all that matters. Because if we are going to pivot to ex ante because we want firms to just kind of take notice and comply, then it needs to be something that they're capable of recognizing and capable of abiding by. My concern, and we'll talk about it later, is that with the current
I just wanted to, we are going to touch all these issues in the other topics too. So
I'm just teeing them up. I'm just giving you the agenda.
Okay. Sorry?
Okay. I'm just giving you the agenda for later. So
that's perfectly fine, but maybe we will open them up a little bit more deeper later on. I just wanted to first get your comments on how it relates to existing competition policy. I very much appreciate that, you posed saying that we had this systematic issue in the past in those digital markets, and that's a, I think, great point to start. And the objective is basically to discipline these issues that appeared in the past. And I would like to just let you finish and then move on to Monica to ask her whether she would like to add something on that. So just, briefly, and then we move on to Monica.
Okay, are you saying to me I'm out of time? Is that your point?
Yes, exactly.
Okay, I'll then stop. But I'm happy to stop here.
Okay, then, we will get back to the issues that you already raised. So it's great that you set the agenda already. So Monica, would you like to add this relationship of the existing competition policy enforcement with the DMA report rules?
Okay, so let me get started and say where I see that this differs from usual competition issues and why it's important that it does. We know that the digital markets are characterized by large network effects and economies of scale. And so we see these huge platforms arising, and they may be arising because of anti-competitive behavior, but that needn't be the case. So they can also be arising just because of these specific market characteristics, which means that the competition policy alone, competition law alone, would not be effective reining in these dominant gatekeepers. Having said that, my understanding is that the Digital Market Act was also motivated simply by the frustration, as Christina pointed out, with antitrust cases like Google Shopping or Google Android, where we saw that the behavior remedies that were imposed in the end didn't work out. And so here we see that the question is that digital markets develop very rapidly, and that competition law simply may not be moving sufficiently fast. And the idea of this DMA is really now to set up rules that rein in this gatekeeper. And so the advantage would be that this can be done very quickly, but, and here also, as Christina already pointed out, that's particularly true if the rules are self-enforcing. But as I have doubts that this is in fact the case, so that this will be working out. Another very obvious advantage of the DMA is now that you can establish these rules in this Single Market Act without having to require a unanimous vote. So if you wanted to change competition law now, you would have to have a unanimous vote, and that is very hard to get. So here we have the advantage. We don't need that, we just need a majority. And so in that sense, I think it's a step in the right direction. It tries to move where competition law right now cannot move. But having said so, let me point out a few things that I do think are not working well yet in the way it's set up. The whole idea of this DMA is to bring up these overarching goals, contestability and fairness. They never really define what is meant there. The idea of contestability, I think, should be to encourage competition, but then the question is, how do you encourage competition? So here I would like to refer to a policy paper that will be coming out soon with a group of US and European economists, and two of them are sitting here with me, so Fiona and Amelia, where we try to give an interpretation of what contestability and fairness should mean. And at this point, just want to point out that we very much think that it's not just having contestability in the sense of lowering barriers to entry, but really encouraging competition in the market, not just for the market, but in the market. And the other thing about this fairness consideration is that it would give a chance, I'm not sure that it will actually be executed like that, but it would give a chance of talking about fairness in surplus division. Why is that so interesting? Because who creates surplus? It's not just the platforms, it's the users who use the platform because of the network effects, but they don't get anything of this surplus, or very little, let's put it like that. And for efficiency reasons and to encourage innovation, it would be important that they participate in this surplus. Now, again, this is something we think that usual competition law doesn't give you. So usual competition law doesn't look at how you divide the surplus. And this is where the DMA could make a move, but I think we need to work a lot to convince the participants that, and the lawmakers that this is indeed how it should be interpreted. And with that, I want to stop.
Thank you very much, Monica, for these extra points. I think it's important to underline contestability and fairness, because as you said, these were the key matters mentioned by the DMA report, but not very well explained as the main objectives. And we will come back to this with the last part of the topic. So I want to turn to Isabel and ask her opinion about, in general, the role of competition law in shaping digital markets in the future. So what would you say on this issue, Isabel?
Yes, thank you. And maybe I will start by taking up what Christina said about the reasons for the DMA, because it is true that for many supporters of the DMA is conceived to be an alternative or an answer to perceived failures by competition policy, competition enforcement, or competition law. And I think that's a possible way to look at it, but this is not exactly how I look at it from my side. First, I think that when you look at the developments of big techs of the past few years, well, at least from my personal point of view, I don't see the landscape as completely black and completely something to be worried about. I think, and I would like to take the example of the pandemic. You know, we've been spending more than a year working from home at distance with discussing with families, companies, and we have had some excellent digital tools to use. And we have been able to shop online, to use all those tools. So first thing is that the digital economy is not bad and worrisome and completely a failure. And I think it's always important to have in mind. And it's also important to really understand what you are looking for through the DMA to be sure that the tool will answer to your needs. And I think that my view of what competition enforcement has done is not as bleak as what Christina was saying earlier. Of course, there is the issue of time and the 6 or 7 years of Google shopping, and we all know that, and I think nobody will debate that this case has taken very long and it should have been faster. But another perspective maybe is that when you look at, for example, complaints that the competition agencies such as the French one has received concerning digital giants, we have had very few complaints. We have tackled all of them, and we have had 2 until the last few months against a digital big tech. So we know there are some elements of companies that were not daring maybe to file complaint, but that's not something in other sectors where we keep on having a huge number of complaints, for example, in telecom or the energy. So that's maybe to put into perspective the fact that competition enforcement has been a huge failure and that digital economy as such has very serious problems. Maybe I would not say the same in concerning GDPR and issues of data privacy, but I think that as a whole, where competition enforcement has really felt to be lacking is to issue to deliver quick fixes to problems and to have fast answers to problems concerning, for example, small and medium enterprise. And so, as Christina was saying, Google shopping was not about a huge market. You know, comparison shopping is very important to the actors that are in this market, but it's not like the big sector of tomorrow. So I think that the only thing I wanted to underline was that we have identified some things that were lacking in competition enforcement, and over the past few years, there have been answers like more use of interim measure. The Commission is starting to do it, like some in national competition agencies. So what I think that the DMA is trying to do is, I would say, a little bit different than answering the perceived ills of or failures of competition enforcement. It's more deriving some more specific rules and apply them horizontally to all players that are supposed to be more or less alike. So that's a big difference from competition law, where you have very general rules in Europe, at least with 101 and 102. And it's more for me a sort of follow-up on competition case. So it is supposed to be, for example, when you look at the rules, you think of all the different closed cases or even ongoing competition cases. And you see that the logic is, for example, take Google Shopping and say, oh, I'm going to prevent self-preferencing, and I'm going to write it a little bit more detailed than it is in 102, so that there is no debate about the fact that self-preferencing is good or bad. So for me, it's more like a sort of child of competition enforcement than something completely different. So this remains, so to say, in the family. And maybe to get back to the answer that was asked to me, what will be the future role of competition enforcement? I think that when you create a new rule or a law, it is very difficult to know which law will be applied more than the other. And for example, on the national front, you can issue a complaint in front of the competition agency, but you can also go to a commercial court. You have several issues and several law instruments that you can use. So we will see in the end which companies feel is the best way to go. Is it the DMA or is it competition enforcement? And also from the point of view of the agency, will they be using more the DMA at the European Commission, or will they rely more on competition enforcement? And I really want to say that for me, those two tools at the moment are complementary, because the competition law has the advantage of being very general and not being too specific, like Article 5 and 6 of the DMA. On the other hand, the DMA really wants to provide some added benefits in being more self-executory and faster. So we will see. We will see if that is the case. And maybe just to finish about that, it is interesting for me to compare the DMA with past laws that had already been focusing on some players. And I would like to give the example of the platform to business regulation. That was already a law with very specific rules and only applying to a specific set of players, which were the platforms. So I will stop there for the moment, but I'm happy to come back to that subject if that's of interest to you. Thank you.
Thank you. Thank you very much, Isabel. I think now it's good time to get some questions from the audience. So I'm looking at how many questions. I think we have the first question from the local audience. Tommaso Dusso from DIW Berlin and Technical University Berlin asks one question to the panelists. So he believes, Tommaso, that the DMA is really needed and have big hope for it, but are you concerned that having an ex-ante regulation could backfire and lead to even less tough enforcement of competition policy? You mentioned this role of complementarity. I think Tommaso is asking maybe they will be seen as a substitute, maybe.
Sorry, the question was for who?
Sorry? It is, I think it's for the all. If you would like to start, Isabel, you're free to go ahead. I don't see other panelists, maybe.
Maybe just on this matter of substitution, I think that the DMA provides very clearly, and that is very important, that the DMA is without prejudice to competition law. So it's very important to underline the fact that there is no exclusion from competition law to substitute DMA enforcement. And that is very wise, because I think that we will have many issues of cases that can be looked through the DMA lens or through the competition law lens. So that will lead to some problems I will allude to later. But at the moment, I think that there will be the choice between those two instruments for several enforcement issues. That is good for an enforcer to have the choice. Like sometimes we have the choice also with national law and European law. That is always very useful.
Could I come in on that question?
Yes, great.
I was just going to say that I think there is an issue in terms of competition law and abuse of dominance, etc. But I see even bigger risk in terms of mergers, and I know we're going to come on to mergers later, but I think there is a real risk that firms are going to say, this merger is now fine. It might have been a problem before, but now it's fine because there's all that regulation that's going to protect people against adverse harms. And I think that that's really quite dangerous. And what we know is that if you have a firm that is merged, it gets much harder to prevent it from behaving in anti-competitive ways than if it wasn't merged and it was two independent bodies. So I think what we need to make sure is that we don't assume that whatever we're trying to do in regulation, that is a perfect solution, and that therefore that allows for mergers to go through which shouldn't.
Thank you, Amelia. So that definitely, we will touch on this issue later on, how the merger policy could be affected by the DMA, basically. But I think it's important to keep an eye on, even though intention of the DMA is to complement existing competition policy rule and enforcement, the parties might make it as if it's a substitute. And that I think the enforcers have to be very keen on understanding the incentives of the parties and not get, again, played against the rules. So we move on to our second topic after there are no more questions from the audience. So I would like to introduce our topic first. So our second topic focuses on the definition of gatekeepers given in the DMA report, and what are the important restrictions or the rules imposed on the behavior of the gatekeepers, and in particular, which core platform services are covered by the DMA. So, dear Amelia, would you like to start with gatekeeper definition and the core services covered and which should have been covered? I think it's a very important topic to discuss.
Thanks. And thanks to BCCP for inviting me. And I would just highlight that I have no conflicts to disclose, but I should emphasize that I'm not speaking for the Competition and Markets Authority. I'm speaking in my own in my own self. Just to highlight that in terms of the design questions around the regulation, I think it is really important what we were just discussing about why we have the DMA. And I think there are really two key reasons. One, which Christina highlighted, which is about the failures of antitrust, that it takes a long time, that it's very piecemeal. But the other that Monica highlighted about the inherent characteristics of these markets. And I think that means that we really need to ensure that the regulation both has the ability to have pro-competitive interventions that open up markets where there may not necessarily have been any intentional anti-competitive harm. And that goes to things like interoperability and data portability and data access. But it also means that we really need to ensure speedy action before markets tip or before market positions become too entrenched. And that's really not straightforward at all against these huge and highly litigious firms that have very deep pockets. And so I think a really key thread going through the rest of the discussion will be about really how you get the right trade-off between right. Because what you don't want to do is do everything really quickly and do all the wrong things really quickly and create lots of unintended harm. You know, Mark Zuckerberg says it's great to move fast and break things. You know, there is a real risk here that if we move too fast, we could break a few things. Equally, if we move slowly, Fiona.
He probably doesn't want us to break his company.
He probably doesn't
move fast.
Him, no. But he said it. But you know, if we move too fast, if we go too slowly and try and get things perfect, actually that won't be perfect because we'll have moved too slowly, and there's a real cost in doing that. So that's just kind of general background to the design question. So then Christina already mentioned that the regulation is in everywhere that regulation is proposed. The intention is that certain firms would be designated. In the EU, they would be designated as gatekeepers. And it is very clear, as Christina said, that the basic motivation for this regulation is the top 4 or 5 firms who control whole ecosystems and have given rise to kind of all the key concerns really that we have seen so far. There is some debate about the next rung of firms. So the Spotifys, the Bookings, the Ubers, the Shopifys. I haven't seen any serious desire to include them, at least as yet, but there is some desire to retain the flexibility to do so, some sort of discretion to do so if some of the same sorts of issues arise. There's also quite a lot of desire not to include firms kind of inadvertently. So things like Oracle, SAP, MasterCard and Visa, the London Stock Exchange, the New York Stock Exchange, the Chinese digital platforms. No one's been talking about them. They're not the motivation for this, but there is a risk that if you design your criteria for designation wrong, you could capture all of those by accident, essentially. So I think the proposed criteria for designation have really been set on the basis that to try and really get those top 4 or 5 firms in, but retain a bit of flexibility, but not accidentally get lots of others in. So in Brussels, the requirement is that a gatekeeper must have an entrenched market position and an important gateway core platform service. In the UK, you have to show entrenched market power, which is actually arguably a bit more difficult because you have to show market power. Is that going too far beyond, the kind of administrability objective? Interesting question. The EU also has this quantitative shortcut. If the firm is just big enough, it's rebuttably going to be designated, which also makes it pretty easy and brings in those 4 or 5 pretty fast. I think the key question that I would just leave you with is that actually you can see those 4 or 5 firms getting designated very easily in the EU and fairly easily in the UK. However, the regulations in both the UK and the EU will only apply to the designated core platform services of those firms. And actually, there's been much less clarity given to how you identify which those core platform services are. Some of them are kind of obvious. We all know that Google search is going to be one, and we all know that Facebook social network is going to be another. But what about Facebook Marketplace? What about Gmail? What about all these other things? Are they going to be included or not? And I think that the regulations are far less clear there. And I'll leave that for now.
Thank you very much, Amelia, for this nice introduction. So I would like to turn to Fiona about the actual rules of the DMA. So would you like to add something on this? So what are the rules that impose on these gatekeepers?
Yes, thank you very much, Oslam and BCCP, for the invitation to be here. In the past, I have consulted for Apple and Amazon, but currently I don't have any conflicts. I wanted to talk about the business models because I find them quite frustrating. I find the rules quite frustrating as an academic. There are 18 of them, and they're not conceptually organized in any way. They are not clustered. We're not told what the theme is or what the object of each one is. And the result of that is that it's quite difficult to think about what might be missing from this list or what shouldn't be on the list. To be able to figure out what's missing, you need a conceptual category to fit it into. And Christina and I worked through this initial list when it came out and tried to fit each one to a company or companies or a case that we knew about. And quite a number of them fit that way, but they're not written to be about a particular named company. They're written as a general rule, so they apply to every platform that's got a core platform service. And this can be confusing. And this is, I think, why the self-execution part is somewhat aspirational here. It's not clear exactly how we're going to know. So for example, let's take 6.1D, where the rule is don't do the rankings in a neutral way and don't preference your own product. Okay, this seems to me to be a clear reference to Google Shopping, where Google was ranking the other shopping services lower and putting its own at the top. But of course, it might also apply to Apple's App Store. If I search music, what will I find at the top? Might apply to the Google Play Store, same idea. Might apply to third-party merchants on Amazon. Is Amazon listing their own things ahead of the third-party merchants? But then, I don't know much about cloud businesses. They're covered by the DMA. What about social networks? Who's to decide whether one friend is more of a special friend than another friend? Is that, and if the other friend makes more money for the social network because they post or generate more content, is there an incentive for the social network to put that friend at the top? And you can see that it just, the kinds of, I could keep on with these kinds of questions, and therefore it would be clarifying if we knew that this 6D rule was meant to apply particularly to search or particularly to e-commerce or something, and not just be across the board in a way that makes it difficult to understand. And also perhaps for it to fit in some of these different business models, it would need to be adjusted slightly. And so then you wonder, if you're going to adjust it slightly for e-commerce, do you then have to adjust it back if you're going to social networks, or change it again for search? So the rules, for this reason, I feel they're hard for me to fully understand, and I wish they were categorized and motivated in some way that would help me cabin them a little bit so I could understand better what their limits are.
Great, thank you very much for this addition, Fiona. I completely agree with you in terms of how to fit these rules in different categories of business models. And on this note, I would like to turn back to Christina. I know that she has done also some work on this together with you, and her experience even way before the whole discussion of regulation started. So how important is business rules? So would you like to add something on this, Christina? And also I want to know...
Thank you, Özlem. I'm happy to, because the business model idea is something I've pursued for at least three years. I've started writing on that early on. As Fiona said, we worked together on this article, which was really trying to fundamentally squint at these rules, as she described, and trying to say, which case is this? Which company is this? So this is all great, but we need some sort of organizational principle. I don't want to repeat the points that Fiona made, because we agree enthusiastically on that. To me, one alternative to having a UK-style, bespoke, company-specific code of conduct, which is something I like very much, an alternative, if you don't want to go there, could be to try and organize these rules around business models, because ad funded, it is different from transaction, is different from platforms. So the difficulty there, and what we really need to strive for, is self-execution. I am advising some of these companies, and you know what the position is? The position is, I'm going to put together a great compliance program. Tick, tick, tick. I'm going to say, I'm compliant. Okay? Don't self-preference. I don't. You have a problem? Send me a letter. So the point is, how are we going to enforce this thing unless it is specific to you, and you have to do these things? Fiona gave some great examples. There are others. The point here is that unless we are telling companies, this is what, of these 18 rules, you should be actually applying to. Now, I was at the other day at the competition day. Olivia Gersan said, but these companies would proactively come in and tell us, we're going to do this and this and this. This is not what they're going to do, because they're not even thinking about doing that. They're saying, I'm compliant. I'll wait for a letter in the post. Have you got a problem with me? So the point is that unless we have something which is clear in some way, we are not in any way capable of self-execution. So really that One alternative, and that's the last thing I'll say, is that, again, maybe one could build into the process an intermediate step as between, just after the designation, in which the companies are expected to actually proactively interface with the regulator about defining that set of rules that applies to them. Because if we don't do that intermediate step and just we leave the 18 rules and we expect companies proactively to say, I'm going to just kind of, no, it's not going to happen. They're going to say I'm compliant. So that's my point.
That's great. I wanted to ask you then, would you recommend or would you think that that would be better if, for instance, the DMA adjusts such that it sets out the rules for saying, ad finance platform, Google, these are the rules that you have to comply with, point. Social media platform, Facebook, these are the rules on the marketplace, these are the rules on the social networking. So would you go that deep into details when you describe? What would be the counter fact of this?
So, one needs to map into the underlying economics of the business model, fundamentally. The underlying economics of the business model is about monetization. How do you make money? So if you are ad funded, you monetize in a particular way. If you are a transaction platform that monetizes through a commission, then you have different incentives, for example, to preempt or allow for multi-homing, do things that restrict the ability to multi-home. So in those cases, we want to look quite careful at any conduct that may restrict the ability to multi-home, which we know is an important thing. So what I'm saying is, one can either go the bespoke kind of way and say, like the UK, and Amelia can talk about this, but the UK is going to give a code of conduct which is specific to each platform. If you don't want to be so close and personal, and you want to say, well, there's types of platforms, then we can have ad funded, we can have a transaction matchmaking type of model, and you can have an app store, cloud type of model. Or you can do what I'm saying, which is possibly you build into the compliance stage a situation in which after the rules have been listed and the gatekeeper has been designated, then there is an obligation for the regulator and the gatekeeper to come to an agreed set or subset of those rules that they will be expected to meet. Something has got to happen, because otherwise people are going to be dead. That's what's going to happen.
I agree with Christina. I would just remind everybody we don't have laws that have names in them, so we don't have a law about Google or Apple or something. But we certainly could think about, if you run an e-commerce platform, here are the restrictions. If you run a social network, here are the regulations.
Yeah.
So it has to be more precise than what the 18 rules do currently, basically, this idea. Yeah. So Isabel, would you like to add something on this issue of how specific the rules description should be to make it enforceable?
Yes. Maybe one comment about the gatekeeper designation. This has been in the debate, and I wanted to underline that what is in Article 3 of the project DMA is really quite sophisticated, because usually when you draft a law, you either have a sort of legal definition in literary terms, or you have some quantitative criteria. And there we have something that is quite sophisticated, because the definition on point 1 of Article 3 is based on general terms, a significant impact on the internal market, you operate a core platform service, you have an entrenched and durable position. But then there is this presumption that comes into play with the quantitative criteria, and I think it's quite an interesting way of designing things. I think I don't have a precedent in mind where you have this type of system. So we will have to see if it works, because I've seen already in the past few months that some participants in the debate wanted to put in even more sophistication in the criteria to designate a gatekeeper. But when you look at the whole of Article 3 as it stands today, it is already quite sophisticated, because usually when you have the article that defines to whom the regulation applies, it's much shorter. So I just wanted to underline that even at the designation process, we might have some surprise, and it might take more time than what is intended. And Christina was saying the same thing, that you should not even be able to contest the fact that you are or you are not a gatekeeper. So I'm not sure that this can be maintained in compliance with the rule of law, but that is a debate. You know, how long will it take to say to whom those rules apply? That's I think an important issue, and I think in the next few months we'll really have to be careful that whatever the quantitative threshold, we are sure that we do not lose too much time in that stage, which is of course important issues. So without coming from a general category, but more by a sort of checklist of problems that were perceived to need to be solved. And I think that one of the answer that I've been thinking about filling that gap that Christina, for example, was mentioning, that maybe those provisions remain too theoretical or not sufficiently identified to a given company and a given service. We had thought about having another provision in the regulation that might be inspired by what is in Article 7 today, and to give the power, and not for me an obligation, but the power to the Commission to come with a specific decision that would tell the gatekeeper, well, in your case, Article 5 and 6, those obligations mean this for you. And so it would not be an obligation, because for me, this would be a problem if for all the obligations, the Commission has to take a specific decision. But I think it might be useful, at least for some cases. And when you look at the list, for some, it might be more necessary, maybe about interoperability or maybe access to data, to have a sort of more precise sheet list of what you have to do. And this, I think, might remain with the general scope of the DMA as it is. And I think this is something that we have proposed on the negotiation, and that might help to have that enforceability that I think that the DMA is striving to achieve.
Great, thank you very much for, yeah.
Could I just add a tiny thing, which is that there's a very good Sarah report, which I was involved in, that came out recently, which also argued that for data portability and interoperability, those were two where the Commission ought to be required to do further specification, because they were so far too wide-ranging, but at the same time insufficiently precise. And also that there should be much more potential for commitments at an early stage if the Commission thinks that there is a problem, but that then if the commitments aren't held to and you end up in enforcement, you would be treated even more vigorously, having kind of been through the commitments process and then not abided by it. So I think that kind of fits really nicely with some of the things that have been said.
Thank you very much, Amelia.
Can I add one more comment? I think what we have heard now also indicates that the enforcement capacity should be using the regulatory dialogue more than it's currently in the rules. I mean, it's as a provision in Article 6, but not necessarily for Article 5. And this regulatory dialogue would solve quite a lot of these issues if you could have specific interaction with the companies and sort of tailor your rights to their specific business model. But that also means you would need to have a lot more people enforcing this. So the current number of 80 people is just ridiculous, given the size of the task.
Can I add something to that very briefly, Özlem? I agree with Monica. I mean, but there is also a tension there that we need to be careful to. Because, of course, we all like the idea of participative antitrust, but I also worry enormously about the potential for the slippery slope into capture. Okay? So we all know, and in my infancy, I was a junior consultant and working in electricity, and we used to go with the band to Enel in Rome, and there were Tuesday afternoon meetings in which the consultants and the regulators and Enel sat together, and it was a love fest. Okay, it was a love fest. We all kind of eventually loved each other deeply, and nothing got done. Perfectly nothing. It was supposed to be breakup of NL and regulation. Nothing got done. So I worry about the slip into capture. At the same time, there needs to be some measure of dialogue. I agree with Monica, because either the rules are organized reasonably clearly into some buckets of business models that effectively you can't escape, or in some way you need to be told what self-preferencing means to you. Because some people say, well, self-preferencing is self-evident. You shall not self-preference. That's it, it's super clear. But if I'm one, I say, I don't know what you mean. I play dead. What are you talking about? Me self-preferencing? Would I do such a thing? So the point is that we need to be precise. And I agree that we need to somehow find a middle way between falling into bed with this thing and somehow just being a bit more prescriptive.
Definitely. Thank you very much for this note. So I think it's a good time to move on for the questions from the audience. I see that there is one question from Dr. Oles Antrichuk, University of I can't pronounce, from Glasgow. Sorry for that. In light of the parliamentary draft report suggesting substantial quantitative, basically 65 to 100 billion, and qualitative from 1 to 2 entrenched core platform services amendments. So this is referring to the parliamentary draft report. So the question is the scope of the potential addressees, so the subjects, is narrowing down from 20 to 5. In this sense, the proposal appears to move closer to those mandatory codes of conduct as are considered in the UK, which supposedly will be fully individualized. Could you please elaborate on this? So who would like to talk on this?
I think Amelia would like to talk.
Yeah, Amelia.
Well, I mean, I think that there's two different things in that question. There's who is designated, and it is true that the EU quantitative test seems to be being further refined so that it is very clearly just the big 5, which I'm sure that the next ones down the rungs will be very pleased about. But I think that's a slightly different question to the extent to which these rules are bespoke for those top 5, although of course, if you only have 5, there is more potential to make them bespoke because you can kind of spend more time on each one. So I think that I think that it makes sense, and actually we're going to come on to the US rules later, but the US proposals are also very, very clearly just trying to get those 5. So I think that, you know, that does seem to be the direction of travel at the moment.
So I think it's a good time to move on to the next topic. I think this was something already mentioned, importance of merger policy and innovation and how the DMA is interacting with the merger policy. So I would like to turn to Monica, start with you. How do you see the DMA rules for gatekeepers interacting with the merger policy? And do you think what would be the DMA rules that imply for innovation? What would be the implications for innovation?
Okay, let me get started by apologizing for not having disclosed or not speaking about potential conflicts. So, and emphasize there are no conflicts to disclose. So I haven't got rid of that. Let me get started with the merger issues. So the current DMA does not address mergers of gatekeepers in a way that would help now prevent mergers of gatekeepers more effectively than it's currently done. And we all know currently it's not done well. And that sort of makes no sense to first let gatekeepers acquire more and more dominant, more and more companies become more and more dominant, and then rely on DMA to keep them at bay. I think Christina put this very nicely in the beginning. Now we see that these recent mergers, they have shown that it seems very difficult to prevent mergers that are likely to have very harming effect on competition. So we saw that in the Google Fitbit case. Now, why did the Commission not prevent this merger, even though lots of economists warn strongly against the negative effects of competition, while here in the market for e-health, Well, rumors have it that the Commission was worried that such a decision might not be upheld in courts, which indicates that the current laws do not adequately account for the dynamic dangers arising from mergers, or that the courts may not adequately appreciate these dangers. So both things are possible. And the question then, of course, is why would we now more worry about these kind of mergers? Well, let's take a look back. It used to be the case that for vertical and even more so for conglomerate mergers, you thought these are not really problematic mergers. So way back when in the 2000s, when in the economic advisory group for the chief economists, we were talking about the guidelines for horizontal, for vertical, for conglomerate mergers. The idea then was, well, in case of vertical mergers, conglomerate mergers, it's really about potential efficiency gains mostly. There was rather little concern that these mergers would be harming competition. But that's very different today in a world where you have data or that is gathered in one market and which is then employed in other markets that are in principle completely unrelated, but where the connecting link is now the consumer and his or her characteristics and preferences. And this is why these markets are now connected. So if you collect data in one market, that gives you a potential decisive advantage in a seemingly unrelated market. And this is why we are so concerned about the mergers. Now, the current DMA just requires that you inform about mergers. And that clearly is not enough. So of course, the problem is the DMA is designed such that it doesn't require unanimity of votes. I said that before. But the question is still, could we get into more rules that would be helping even without requiring unanimity? And the German Ministry of Economics, for example, has proposed to change the DMA proposal such that at least you include the requirement to notify mergers. Now we would have to discuss in detail what's the difference between the two, but there has to be more, let's put it like that. There has to be more than we currently have. Now, if the current status is such that the mergers cannot be prevented, then it's even more pressing, I think, to consider the structural remedies like divestitures as appropriate measures. And again, in the DMA right now, that's mentioned only as a measure of the last resort. So only if behavioral remedies are not equally effective or are more burdensome, something like that. Now, Andreas Schwab, the member of parliament who is the rapporteur for the European Parliament on the DMA, he has included in his report the option to consider structural remedies as well as behavioral remedies, but in particular when there is systematic non-compliance with behavioral remedies, and in this case, meaning 2 cases of non-compliance. Of course, here it's not clear, do you mean non-compliance with the word precisely of the remedy, or is it with the effect that is intended with the remedy? And that is a completely open question that he himself couldn't answer yet. But here we think that it would be good to go beyond what is the current proposal of the DMA. And we will hear in the 5th panel that one of these 5 US bills actually goes much further and requires divestitures in cases of conflicts of interest. So Fiona will talk more about that later on. I think in general, the advantage of such structural remedies is that in contrast to behavioral remedies, it does not require constant monitoring and regulation. And we simply see that behavioral remedies do not necessarily work if the companies work around them. We saw this with Google Android, for instance. And therefore, having structural remedies would be a way to go forward. And let me conclude here by saying that we saw in the case of the Bell system, the breakup of the Bell system, that was a measure that was imposed after decades of regulation and decades of frustration with the ineffectiveness of this regulation enabling competition. As Christina said, I mean, you just get too close with your regulator, and in the end, it's not working anymore. And here we have seen that this breakup was creating a lot of innovation, and I would expect that also from rules that prevent mergers, that impose structural remedies, or because you give the companies an incentive to work towards innovation that really captures new markets, new customers, and not simply innovation that helps you defend your monopoly position.
Great, thank you very much, Monica. I have a question for you, but I keep it for the Q&A. So it's about the vertical mergers. I think it's an important issue to highlight. So I want to move on to Amelia. Would you like to add something on this relationship between how we should approach merger policy given the rules outlined in the DMA?
Well, so I was actually going to say something about what was happening or what was proposed in the UK, if that's okay.
That's perfectly fine.
I know that the DMA only refers to the information requirements. I know that that Isabel may well be able to say more, but there is thinking being done on expanding the ability for the EU to look at mergers, so to gain jurisdiction over mergers that might be problematic. When we looked at this in the UK, we were actually pretty happy with the UK jurisdiction. We've got a pretty broad jurisdictional rules, and we've just had a big appeal in the UK, which essentially confirmed that the CMA has an amount of discretion in terms of its jurisdiction. But when we looked at mergers with the Furman review, we concluded there were kind of three main issues and made recommendations in each of them. One was actually just a general lack of inquisitiveness into these mergers, and that fitted with actually a LEA study that I know Tommaso Duso was involved in. Which basically said we weren't asking the right questions. We weren't really understanding these markets. We weren't being critical enough about some of these mergers. And I think that the CMA has really stepped up on that. I think they're being really, really very careful in looking at mergers now. The second was in terms of the merger assessment guidance, just not helping. They had a very benign view of non-horizontal mergers. There was almost nothing on harm to potential competition, almost nothing on dynamic theories of harm, so harm to innovation, almost nothing on the role of data in these markets, not too much even on two-sided markets and how to assess mergers with two-sided platforms. So we said, look, that assessment guidance just needs to be updated so that it is actually helpful for looking at these mergers, but also signals a change in approach. The final thing, though, that we were concerned about was the actual merger test. We thought that when you look at these mergers, there's very often significant uncertainty about the facts. And as we discussed earlier, you're up against a firm with huge deep pockets to fight you on the facts. And the test in the UK for blocking a merger is a balance of harms. Actually, there's a recent EU case which seems to have set the test even higher than that, which is a real problem, I think, in the EU. But in the UK, it's balance of probability. So you have to get above 50% likelihood of harm in order to block a merger, or that's kind of often how it's perceived. And we said, well, hang on, an economist would say that if you had a 25% likelihood of really bad harm and a 75% likelihood of whatever, then that's a merger you should block because you've got a 25% likelihood of really something very bad. But if you have a balance of harms, a balance of probabilities approach, so you have to get above 50%, you couldn't block that merger. And we actually realized that almost all of the economics papers on merger policy just assumed that the merger test was an expected value test of the sort that we thought that should be the test. So we basically made a recommendation that the law should move to what all economists thought the law was anyway. That unfortunately has not been taken up by the CMA or the UK government. But there is now a new recommendation, which is that at least for the SMS firms, so the designated firms, there should be a lowering of the threshold to the test to go to the second phase. So basically, you just have to be able to show a realistic prospect of harm rather than hitting the balance of probabilities. That's now with the government for thinking about, but I think it would really, really help in these sorts of mergers.
Thank you. Thank you very much for this note. So I would like to then turn to Isabel and ask your opinion on this issue from giving us a little bit more French point of view on this merger policy, French authorities.
Thank you very much. Yes, over the past few years, we have really spent some time trying to evaluate if the merger control was in good shape in France and in the EU. And we came to the conclusion that there was something missing in terms of a legal tool to be able to look at some mergers that have a very significant impact. And I always give the example of Facebook, WhatsApp, but you could find others that a merger that could have escaped control. Well, it didn't, but it could have because it was below the threshold. And of course, it had a huge impact on the social network and platforms as such. So we had devised some proposal for the French Parliament, and at the same time proposed that the EU could change its interpretation of Article 22 of Regulation 2004 to be able to receive referrals from national competition agencies when those mergers are below the notification threshold. And so we were very happy where after several months and years of discussion, finally the European Commission concluded with us that this was a very good way to go, because we didn't need to have a new legal tool, and this would be applicable to the whole of the EU. So it's even better than what we had proposed that would have been applicable only in France and with more or less the same effect. And we also had made some proposal that we should know more about the mergers which big platforms do without even knowing if they should be blocked or not. We should have more information. So we had proposed that all the mergers done by structural players or dominant players that we would have defined would be subject to an obligation of information to the national competition agency. So we have been very happy to see that idea fit in the DMA, which of course will be only for the gatekeepers, but that is a start. I think maybe we will see if that needs to be widened maybe at the national level. So that's the issue of the tool, to be able to look at some mergers and to possibly control them and either prohibit them or demand commitments, even though they are below the notification threshold. Then there is a completely separate issue, which Amelia alluded to right now, which is how you look at mergers. And then it's a whole different debate, but it's another debate that comes at the same time. And do we apply the good legal test, and do we look at those mergers as we should? Do we take into account sufficiently how markets can evolve, and do we have sufficient information to know whether the social network will be the next big thing or not? So that's really something that we have looked a lot with other enforcers in the past in ICN or ECN discussion. And I think that we have learned a lot by several initiatives. For example, ex post analysis. The CMA has done a wonderful work in that area. In France also, we have been trying to do that to check that we had looked at the merger as we should have with the benefit of hindsight. And so there is the debate about the DMA. Should it incorporate a change of legal test? For example, creating presumptions or changing the way we look at those mergers. I would have to say that for the time being, we keep on thinking on that, and we are really considering all the proposals by academic reports or other ideas on that. We feel that we can already do quite a lot with the existing legal framework, and that already with Article 22 and this whole new range of mergers that we can look at, we can do quite a lot. And as you know, there has been the first referral by the French agency to the Commission with the Illumina Grail merger, which is not a digital merger, but still we feel that it's a very important merger to look at, because it's about innovation in the health industry and it can affect many. So I would say that the Google Fitbit decision was really the one that captured the debate, and it was a very interesting and strategic merger. I think that you can also look at the final decision by the Commission in a positive light by the fact that they have received commitments with a merger that might not have been looked at twice, maybe a few years ago, because it was perceived to be separate markets and not a very big actor per se. So I think that this decision shows some progress in terms of looking at how different markets can interact and the role that is played by data. I know that this decision is felt by many, including which Christina, to be lacking, and that it should have gone further. But I really want to look at it as an encouragement in the deepening of the control and the better, and the fact that we must take into account much better than we did those mergers affecting different sectors that were perceived to be conglomerate and not creating many harm, and also those ecosystem effects that for me are very important, that you can take data on one segment and then use it in another segment and create a data set that the other competitors do not have access to. So I think that one key thing that we'll need to do in the next few months and years will be to look very closely at this Google Fitbit case. Maybe there will be others in the same category that will be looked at by the Commission or by national agencies, and leave open the fact that we will need to change the legal test. As you know, in Europe, this would be quite difficult to do because we would need unanimity to change regulation 2004. So that's not something that we will see, at least in this mandate. But we will see how the DMA discussion will go, but I don't think it's very realistic. But it will be interesting if some national governments go this way and try to change the legal test. There is some debate in some countries. There has been in Germany, in the UK. So we will look at that and see if we have some good ideas to take also at on the national front. Thank you.
Great. Thank you very much, Isabel, for giving this very broad opinion on this different aspects of the merger policy in digital markets. I think it's a good time to turn to Christina because she has been very much involved in this Google Fitbit pre-merger discussion of the economists. And I want to ask you one particular question related to, I want you to tell us your opinion on that, but also, you know, I understand that there are many issues related to potentially data connecting different markets, but also I think other challenge for the authorities is what I see as an economist is that there's a high uncertainty of defining what would be the counterfactual if there is no merger because of the dynamics of these markets. So how would you then combine these trade-off and come up, say, you know, we have to go this way, not the other way, which was the European Commission allowing the merger?
That's a very good question. And I think my answer is that we need to make a policy decision. We need to take a policy view that the political economy is deeply, fundamentally changed. And therefore, the respective weight that we give to type 1 error, type 2 errors has got to change. Because, I mean, enforcement until recently has been entirely motivated by this fear that we should not over-enforce, because if we over-enforce, the sky will fall. Innovation will go by the wayside, there won't be any new product, all of that usual story that we've heard forever. So I think knowing what we know now with the hindsight, with indeed, no one is suggesting that one should be born wise, but with hindsight, I think where we are, knowing the difficulties that we have in taming this power exposed, it's no longer possible to just hide behind the cloud of uncertainty. I mean, this is an incredible kind of conversation that goes on. The platform themselves, ex ante, tell you, you can't block my merger because it's all so uncertain. And exposed, you can't undo the merger. Okay, well, one or the other. At this point, I think we need to take the view, personally, that's my position, that type 2 error are not any longer something that we should guard from so desperately. Because I do genuinely not believe that if we sort of push, I mean, we had all the way here, not certainly a serious level of enforcement. Let's kind of move over there. Do we really think that if we block 3 more mergers a year, Silicon Valley will stop innovating and the incentives to innovate won't be there? It's nonsense. Like that nonsense that if we don't allow this acquisition for buyout, merger for buyout, people will stop inventing. Nobody believes that. So it is an old chestnut about what drives innovation. And certainly what we need to worry about is we're in a different paradigm. And what the UK is doing, which I'm very much a fan of, is really power up things like potential competition, right? They've not gone creating some incredibly eccentric theories. They are powering up potential competition, and they're seeing it as something that we didn't used to worry about before. And they're doing it with force and systematically. So when people say, we are doing okay, we don't need to change the standard, I question that seriously, because we need to review and we need to rethink the standard under which we examine this, the policy that we pursue. And ultimately, the decision has got to be, to my mind, that this isn't going to make the sky fall over. I mean, these deals if you block 2 or 3, nothing will happen. People will go to an IPO. People will go and sell themselves to someone else. The famous story of Plaid in Visa. Okay, so the merger was blocked, and they went and sold themselves to somebody else for a month.
For 3 times as much. Yeah.
3 times as much. So how exactly is that a disaster?
Yeah, I agree. Can I add something there, Christina? Yeah. I agree with you. I think what I hear Isabel saying is that now we have a way to notify these little mergers that we're worried about, conglomerate mergers. And that's excellent, obviously a huge step forward. But that's still different from being able to block them in court. And I even think if you go to expected harm, there's still a problem. I'll focus a little bit on the US because we have a need under our law to define a relevant market. And when you get to these kinds of platform cases where there might be a tool market and there might be one side of the platform and the other side of the platform, and people are transitioning from text to images. So do we really think text and images are 2 different markets? Are they going to merge to become one? It's really hard, actually. It's legitimately hard. And I think that even if we have the right to review a merger as a society, we're going to have a hard time getting courts to be as aggressive as we would like them to in light of the type 1, type 2 error that Amelia and Christina were just talking about. And in that sense, the regulation is a very useful backup. So if these things can't be done through the merger law because there's too much change and we just make mistakes, then we have another chance to try to fix it ex post. And I think what Monica said about being able to break up firms ex post with through a regulatory tool is really a good idea because of this problem. And then also just being able to regulate more generally is also a good idea in light of the difficulty of getting courts to do merger. Again, all of us, I mean, foreseeing the future accurately in this setting.
Oh.
Great note on this.
Could I add one tiny thing on market definition, which is the new merger assessment guidance that came out in the UK, decided, to even my surprise, to put market definition right at the end, thus thoroughly demoting it to the thing that you do when you've worked out whether you want to block or not a merger, and you kind of have to do it in order to pass the legal test, but it's not meant to be driving it's at the decision.
Maybe I can add after Amelia's comment that, as you know, we are reviewing the notice on market definition of the European Commission now for the past few months. And one of the things that is being discussed and that should find its place in the new text would be to question the importance given to market definition as opposed to having a global look at the impact of the merger, which is per se a sort of revolution, especially if it really changes the way the teams spend a lot of time doing that market definition test. And we know that it is sometimes the most important part of the case study and debate with the company. So I think that it will be an important sign. And we know that courts are quite, they take into account these soft law documents, especially in antitrust law. So I think it's an important sign, and we have had a very productive discussion within the ACN on that subject.
Özlem is silenced by her microphone.
Okay, good. Sorry. I did something wrong, but it works again. So thank you very much for this very interesting contrast between how US approaches with the market definition being fundamental and UK putting it at the down to the list. It's a very different approach, and I really appreciate to see this contrast here. And now I think it's a good time to go to the questions. I also have some questions, but let's see first the audience. We have a question from the audience. It's Moritz Müller. He's an economics student at University of Mannheim, and he's writing his bachelor thesis about the Google Fitbit merger. And he has two questions. How trustful or credible are commitments from big tech? The Google Fitbit merger was clear, subject to conditions.
We can read it.
We can read it.
Well, who is going to answer about how trustworthy big tech is? I think I don't know. We have some evidence of big tech promising one thing and delivering something.
Come on. Let's just be saying it as it is. I mean, these kind of commitments are incredibly complicated to police in a way that is effective, right? Just because the asymmetry of knowledge and information and resources is so vast. So with all good intentions, I find it very difficult to believe that an agency can in an effective way, really just make sure that these commitments are policed and they're effective. We've seen it over and over and over again. And
conditions change, by the way. Even as you say, everyone's trying. Even if you have the perfect agency, the world moves, and then you have to reinterpret the conditions.
Yeah, and then who is going to police them? The usual sort of structure is the hapless monitoring trustee. Who is that? Some accountant somewhere who's going to tick some boxes. So, I mean, it isn't a credible solution. I don't think that we can really believe it. I mean, in a world in which agencies were appropriately resourced and had data scientists galore, and they really had an equality of arms, yes, of course. But there is an asymmetry of resources and knowledge, which is incredibly difficult to bridge. So I think people can always run rings around you. So I think that that's simple.
I think maybe to add to the, sorry.
Go ahead, Isabel.
Of resources that is such a big issue. I mean, this is what we hear from competitors of Google, for instance, Google Search, who wanted to enter the market. And then there was Google Android case, and there were remedies. And then Google just worked around, and they have just the resources, they have the lawyers, they have the technicians who can restructure the contracts and the technology such that in the end, on paper, it looks like they stick to the behavioral remedies, but in fact, they work around this. And this is definitely something that competitors cannot do if they're young startups, and that the Commission cannot do either because they simply don't have the resources.
I just wanted to add about this enforceability of commitments that I think we need to believe in them because they are really at the backbone of merger enforcement. I think that in many cases it doesn't go wrong because I think that companies are trying to do it seriously and you have many different types of commitments. I completely agree that those type of behavioral commitments, when they follow only internal process, they are among the most difficult because you don't have the checks and balances by competitors, clients who can check if everything is going okay. So this is more challenging in that respect. And I wanted to add that one dimension to take into account is the risk that the companies take if they don't comply with the commitment. And I think that you really need to be very tough when a company breaches its commitments. We have one precedent in France where a merging company, and it was a very big one in the television industry, that breached its commitments, so its merger be annulled. So they were back to zero, and they had to re-notify, and then the merger was approved with a whole set of very stringent conditions. And I think this may be a lesson to learn from the past. For example, this was not a breach of commitment, but in the Facebook WhatsApp case, we had a case where one key information given to the commission was incorrect, and it really was an information that was crucial to the case. So I think that what we need to see is very serious consequences when a commitment is breached, and including the fact that the merger is annulled. And so this, I think, must be in the mind, and at least at the French Competition Agency, we believe in that. And for example, some years ago, we gave a very hefty fine of 20 million euros to a company that had failed to sell what it was supposed to sell in the merger. And I think it's important that we have at least this deterrent effect in the compliance of the commitments.
I don't know if...
yeah, Amelia, go ahead.
The other question that was in the chat from the same guy about this merger was about the DMA. And whether it could help here. And I think there is one part of the DMA which stops you using data from one service that gained in one service in another service, which theoretically could help with the health data. But it says you mustn't do that unless you get active consent from consumers. But I think a really key thing that they haven't done within the DMA is really think about the choice architecture that consumers face when they're making these sorts of consents. And actually, we know that the way in which these consents will be put in front of consumers will strongly encourage them to basically give the active consent unless the Commission is really on it in terms of ensuring that active consent really means active consent when you think about behavioral biases and dark patterns and choice architecture. The one other point is that in terms of enforcement of commitments, one argument I made in the UK, which didn't end up happening, but partly because the regulator will be within the CMA, was that when you have commitments in relation to the designated companies, there might be some rationale for those commitments then forming a part of the overall regulation and being enforced by the regulator rather than, in the EU case, DG Comp. Because actually DG Comp isn't that great. None of the competition authorities are that great at basically enforcing these commitments, which is a form of regulation, and they are not expert regulators. So there is a real benefit potentially to anything in that space basically being handed over. But that isn't currently the recommendation, but I would argue it should be.
Can I jump in for 1 minute? I'm sorry, Özlem. I know
yes,
we're on
no worries,
time,
no worries.
Something that Amelia said is something I want to be able to expand on later on after the break. Because Amelia talked about something in the DMA that talks about the way in which data shouldn't be effectively stretched from one particular use to the next. And indeed, there should be consent. Now, I want to really fly this flag because it is one that I'm obsessed with. If we enforce GDPR, these things would not happen because the GDPR explicitly says there are very clear provisions about purpose limitation. So data which has been obtained with consent for one purpose cannot be used without explicit consent for another purpose. And if that data is sensitive data, the consent that is required is especially demanding. So we now in the antitrust world are not yet sufficiently cognizant and listening to what the data protection people, I want a complete 5 minutes on this later, to rant to my heart's content, because we're not listening to the data protection people saying, whoa, this stuff isn't really novel antitrust thinking. When you're saying you can't stretch the data from here to here, it's in the GDPR. It's just that we're not enforcing it. You guys need to take this on board, they say to us. What are you smoking? Why are you not seeing what we see? So I think that this is an important portion of the entire discussion, certainly on mergers, because it is the reason why, for example, in a case like Google Fitbit, The Commission is content with saying, oh, we told them to silo the data. Do we have any certainty that the data will be siloed effectively? What is the actual certainty that we have that the data won't be used to stretch to other uses in health tech and so on that is not supposed to be? There is no control. Only the GDPR data protection people out there with their plastic knives saying, don't do that, but nothing else. So, I mean, this is a big problem that I think is missing, and I think we should talk about it later.
Thank you very much for this final note. So I think this is a great time to have our break. So I have other questions, but maybe we are collecting them for the final Q&A session at the end. So let's have a break of 15 minutes to refresh and come back with all this energy again for our topic 4. So 15 minutes break. Great. See you. Bye-bye. Can hear me, no?
I don't know.
Yeah, Isabel?
I suspect we are live.
I suspect we're live.
Yes, we are live now. Yeah. Okay, great. Great to have you back. So we move on to our fourth topic of the discussion today. I think we have already touched on this issue earlier, but we can go deep dive a little bit more. Implementation challenges of the DMA, and in particular with respect to national antitrust authorities. So that's why I want to first start with Isabel. How could national authorities be better involved in the DMA, and what are the challenges for a national competition authority in terms of implementing these rules?
Thank you very much. So I think that to this date, so after a few months of debate, the debate about the DMA has been about, do we need the DMA, which should be its objectives, its legal basis, and its main characteristics. So we have already seen about what should be the remit, the obligations, and the enforcement tools. But I think that there is still a missing link in the DMA that needs to be addressed. That is the necessity for a strong coordination mechanism with the national competition authorities. And I also think that the DMA could be much more efficient if it provides for enforcement by the NCA. So I think that those are two different topics, but that could be tackled by the same provision. And so I will address first the idea that there is a missing link in the DMA, because I do feel that there will continue to be competition enforcement at the same time that there is DMA enforcement. And that today I see as a problem the fact that there is no coordination mechanism between the two legal tools. When you look at the DMA today, you have no specific role or prerogative for the NCAs. You only have the advisory committee in Article 32, but that that article doesn't provide any specific coordination. So why is it a problem? I think that there will be a significant overlap between competition enforcement and the DMA enforcement. And this also derives from the fact that the DMA is very much competition law inspired. So when you look at the provisions of the DMA, you see that this type of problem, this type of conduct could very well be also the focus of an Article 102 enforcement. For example, if a dominant company is the subject of an Article 102 enforcement by us, and this company claims that part of this conduct is covered by a DMA provision, or even is subject to DMA enforcement by the European Commission, this will create a problem, because then we can have all type of legal wrangling and difficulties. And for example, we would have no way of making sure that what the company, for example, tells us about the fact that there is parallel enforcement is true. The company might claim that there is double jeopardy, or that the non-bis in idem principle has been breached. And also there is a different difficulty that the NCA might want to know that the European Commission is investigating something under the DMA, and may take the decision that we do not want to move forward with 102 proceedings if the Commission is addressing this through the DMA. So you can have cases in which you will maintain parallel proceedings between competition enforcement and the DMA. There can be very clear reason for doing that, but we need to be able to exchange information and coordinate with the European Commission, even to decide which is the way to go, if the national enforcement should move forward, or if the DMA enforcement at the European Commission level should have the lead, so to say. And I'm thinking about a recent digital case that we have seen at the French Competition Agency that was related to the new iOS by Apple. And we have dealt with the case at the interim measure stage. And one of the issues is whether a new framework that has been introduced, privacy related in Apple iOS, does it imply self-preferencing from Apple? So you can see that with this issue of self-preferencing, Apple could claim that now this is solved by the DMA, and in the future, this type of case could be the subject of this type of legal difficulties. So I do really feel that we need a coordination and allocation mechanism specific to the national competition authorities. And I think that many other NCAs feel the same, and that we will ask for this to be addressed by the legislator in the next few months. And then there is the issue of merger control. We have seen and said earlier that there is a provision, Article 12 of the current DMA proposal, that provides that the gatekeepers will need to provide information to the European Commission. But then if this information cannot be transmitted to the NCAs, this means that the NCAs will not be able to use Article 22 of Regulation 2004 to decide on a referral to the Commission. So this means that we will not use all the potential of this new treasure trove of information if there is not this missing link that is solved also for merger enforcement on the DMA. And then there is really another issue for us, that is, we feel that enforcement of the DMA will be a challenge for the Commission, because of course the DMA wants to be self-executing, wants to be very fast, but we can see that with each and every obligation that will need to be applied, there will be some difficulties in making sure that it is applied in the coherent manner. And of course, the Commission has said that they were thinking about an 80-person task force to deal with the DMA, which is not a lot. So depending on the number of gatekeepers and the number of obligations, this could be quite challenging. But beyond that, I really feel that using the NCAs will make the DMA much more powerful and would make better use of the human resources of the competition enforcers at the national level. Because over the past few years, we have seen a very big case by the Commission, but we have also seen very interesting and forward-looking cases at the national level in Germany, in Italy, in France. And we also have some teams that are now very knowledgeable about digital platforms and the problems that they raise, for example, on online advertising. Also those teams that have been working on sector inquiry or studies on fintech algorithms, so all over Europe. So what I propose is that we recreate what already exists, that is the European Competition Network, and allow national competition agencies, when it is appropriate, of course, and in full agreement with the European Commission, to be able to enforce the DMA, either by being part of an investigation, for example, receiving complaints or hearing companies at the national level, but also by enforcing the rules of the DMA if that is relevant. And that we know that some gatekeepers are powerful all over Europe, but sometimes the problems arise more specifically in a given country. For example, we have seen that with Amazon in Germany, or with some Google cases that we have seen in France. So I think that the easiest way to do that will be to rely on the ECN as it works in Regulation 1/2003. And so we don't have to define all the rules in the DMA because they already exist in Regulation 2003. But I do feel that this way the regulation will be much more powerful. And also the fact that there is only one team to enforce a tool, of course, this will provide clarity and convergence. But I think that you can also learn a lot from discussion by this global network that we have created over the past few years. And I think that we see already with the classic antitrust cases on digital that we benefit enormously from the discussions that we have within Europe, but also with the American colleagues or Australian colleagues. And I think that also from that point of view, we will have much more innovation and freshness of spirit if we pool those resources as I was proposing by relying on the ECN mechanism. Thank you.
Thank you very much, Isabel, for this very detailed description. I think that made it very clear the existing challenges for the national authorities, and in particular, I want to emphasize your, you raised the concern of coordination I think it was also relevant for the previous cases, but in particular now the DMA rules, I think, open this box of coordination being even more important, and also which rule applies in a given particular case when it's in front of the national authority. I think these are important. So I want to turn to Christina, and because we mentioned already some challenges of implementing this in the first topic, these 18 rules being a little bit too detailed, but at the same time not detailed enough. And what else you would put as a challenge of implementing these DMA rules, and how could these rules be written such that it make it easier to implement?
Well, in a way, I feel, Özlem, we've already kind of touched upon that topic. I want to stay pretty much with the terrain that Isabel has charted out, although I want to be brief because I want to give the other speakers the opportunity to speak on this. And Isabel is really the expert when it comes to implementation. I mean, there is no question that when you think about the DMA text, the whole process of compliance and the institutions that are going to be responsible for it is incredibly vague. So how will they share the competencies is something which Isabel has indeed highlighted, but it is a big question mark. And I completely agree with Isabel that there needs to be a clear and specific and well-established role for the national authorities, in no small measure for the reason that she mentioned too, that some of the most creative enforcement that I've seen in around has come from the national authority. Think about the Germany with the Facebook case. That case is pioneering in so many dimensions. Think about the work that France has done in various dimensions, indeed, in privacy, indeed, around ad tech, and so on. So too, we need a sort of an institutional design that absolutely embraces that and gives the national authority a major role and voice in all of this. In addition to which, we are seeing multiple cases being opened by the national authority right now under one or two equivalent at national level, cases against Google. I mean, Germany certainly just recently opened cases against Google, cases against Amazon, cases against, again, and then there is Apple. So there's quite a lot happening. What do we do with that body of work? It needs to be integrated in some way with whatever the DMA is going to be doing. So I think that it's a shame we don't have Philip Marsden on this panel, not just because I miss him singing a song, but because he's very good on the whole area of coding for compliance, coding for institutional design, designing the process in ways that both allow for some measure of speed. We are not delusional. We don't think that the speed can be accelerated massively, but some measure of speed, some measure of allocation of competencies that is productive and not destructive of knowledge and competencies that are there. I'll just leave it here.
Thank you very much. So maybe
Amelia, I want to say.
Yes, I wanted to turn to other panelists, exactly. So go ahead, Amelia, please.
I was just going to put in one counter view, and I do agree absolutely that the NCAs have to play a strong role. My only nervousness is, and it goes back to the point we were discussing earlier about how broad you make the obligations and then how much of a discussion you have after the obligations have been imposed about exactly what they mean for individual firms and individual services. My inclination would personally be to have the obligations slightly broader and more discussion to really, then set them in carefully in place for each platform, because I think then you get the right degree of kind of bespokeness, but also not tying your hands too much. The problem is you kind of need one body to do that. If you have too many bodies trying to do it at once, it's tricky. So I think that if you wanted to have more authorities involved, you might have to be more precise in your rules. And that might actually not be what we want. So I think there's just a little bit of a tension there in terms of regulatory design.
Thank you, Amelia. So it's a little bit like the, how to set up the governance rules such that we at the same time be precise, but not too much into the details, so that we are not held up by this discussion of the details and they're taking too much time. So it is interesting because I think there's another issue that I wanted to touch on, like national laws are also different in different cases. And also competition conditions, even though we talk about single unique market within EU, we see, for instance, Amazon.com has different, Amazon.fr has different prices than Amazon Italy. So you have all these price differences happening across local markets within Europe. And that also opens a question of type of this competition may be also different. I think there's definitely room for the national authorities to be involved and give their opinion on these local cases in particular. So yeah, I think this is a good time, unless there's another panelist who would like to add one more point, because I see that we have question from the audience. Maybe we take the question, and if you would like to add something on this, we can add later. So we have a question from Simonetta Vezzoso, sorry for the pronunciation, University of Toronto, Trent, how would you say that? Trento, thank you. Some DMA obligations, sorry for, I have no Italian. Some DMA obligations are sort of GDPR plus, for example, enhanced data portability provision. How should the interplay between the data protection authorities play out at the DMA institutional design level? So, yeah, who would you like to take this question?
I'm happy to talk about that. That's my pet subject. So, I mean, I know that Simonetta is very focused on, and rightly so, the privacy data protection piece and the integration, the interface with antitrust, however you want to call it. And indeed, one of the general points I want to make, but it is also specific to the DMA, remains the one I sort of sketched earlier, that we have come to a point where we have realized that the market power that we worry about in terms of its potential for abuses is built on data, which is collected and is used in ways that we have no control over. And in turn, that data, the protection that we have over that data is being degraded gradually by the fact that people who have the market power are flaunting the rules on data protection. So we have a problem, a crisis in a way, in two dimensions. We have a crisis of market power and we have a crisis of data protection. The problem that we've had, and I don't want to repeat myself too much, but the problem we have is that these two views have been so far seen as proceeding in silos. And there is a view which is still strongly held at some level by some agencies, not Isabel, not Andreas, not Andrea, guess who's out there, that somehow we do market power over here and we don't do data protection because data protection is the task of the data protection authorities. So I think that is absolutely a major gap in the way we think about market power and abuses of market power, in the way we as economists, and there's many economists on this panel, fashion theories of harm, because there is a reluctance to articulate theories of harm that build on that data dominance. So I think that unless we integrate that perspective into the way we articulate the theories of harm, we are going to always kind of be looking in a very blind spot sort of way. So that is a bigger discussion. But when it comes to the DMA, it is also a relevant discussion, because even in the DMA, there isn't enough, to my taste, recognition of this issue. And it is a problem that we, the antitrust community, need to somehow address. The data protection people, yes, they have a silo of their own, but they look at us and say, why is it that you don't see what we see? Why is it that you don't really understand that, for example, if GDPR was applied properly, many of the concerns that you have could possibly be at least in part ameliorated? I don't mean solved, but things like purpose limitation go some way in eliminating the potential for extending market power from certain data to other markets. Okay, because if you can't use the data from A to B, then you can't extend the market power from A to B. And if you use data purpose limitation, that is one way to do it. So I think that holistically, and this is something that I feel very strongly about, we need to be much more willing to understand all of this, not say just, oh, we are IO economists, you know, the consumer protection people do privacy, nothing to do with me. Because it is that approach, that attitude that I think is leading to massive elephants in the room not being caught. I mean, this was in part, and I don't want to revisit the case, the problem with Google Fitbit. A lot of people were saying on the data protection side, it's no use preventing the use of the data for more targeted advertising if you do nothing about preventing the use of the same data for health tech purposes, for health uses, because that's where we worry you might extend the market power. And if you don't understand that that's how tech rolls, then you're not addressing the market power potential creation ex ante in ways that then go catch it 5 years from now. So I think to respond to, and I conclude, to Simonetta, I think that we really need to force this perspective into the discussion. We need the antitrust crowd to take this stuff seriously and actually talk to the data protection people. Yesterday, last thing I'll say, I had this event. There was the data protection supervisor. He was fantastic. He essentially, in a very candid, very open way, said, look, we haven't made any progress. There's just kind of cheap talk from the antitrust agencies about talking to us. I know this isn't the case in France. Camille is very close to the DLC, but in Brussels it is. Remember at the beginning of Google Fitbit, the data protection supervisor would just said, don't call us, we'll call you. Okay? So, I mean, this is the problem. And I think it needs to be thought through.
Great. So indeed, I wanted to clarify, I completely understand your point, but I think when I was looking in this issue about whether privacy is something about competition policy or not, it's true that we can build a model of quality which relates to the privacy, but there is also a lot of behavioral aspects in there, that how much consumers understand those, you know, like consent agreements sent by the platforms when they say, do you agree that I share this and that? They have no clue what is in those agreements and they don't know the consequences of it. So it's true, in principle, in theory, firms could compete on the privacy dimension and the quality dimension, but in practice it doesn't happen. So I think that's why...
Yeah, I just feel so strongly about it. And then I'll shut up and let Amelia and Isabel speak. I think this framing, privacy is a dimension of quality, so 2015. We need to move beyond that. Because I hear that all the time. We take it into account, it's a dimension of quality. It isn't. It's like a price increase. The problem we had in things like Google Fitbit was when I was talking and I was advising for free or talking to regulators on that, to the ACCC, for example, they were sort of hearing what I had to say. And the kind of dialogue was, but in a competition case, we need to show there is a reduction of competition. Okay, so the firms go from 4 to 3, there is a competition effect. If you're talking about a concern you have about degradation of privacy, I don't know how to frame that in competition terms. I don't know how, what is the reduction of rivalry that brings that about? I can't pursue it. And that's why we have all of these cases that are about exclusion, leveraging, foreclosure, and not about exploitation. So unless we economists kind of say, no, we worry about price increases to consumers in a merger, we worry about data degradation, privacy degradation as a price increase, equivalent to. I get that the work needs to be done, but unless we think about it in the right way, it will never happen, because then we can wave our hands. You know, quality is a dimension, privacy is a dimension of quality. You know, with a merger, quality can go up and down. I don't know what to do with that. So that's my question.
I completely agree. I think we need models first to make this explicit, and also the empirical theorists and the econometrics experts to measure it, what it means in practice, this quality aspect of privacy. So I want to turn to, I think there's another question, but I think we are a little bit over time in terms of our second topic, unless Amelia, you had something to add, or?
And Isabel, yeah.
And Isabel, okay. Then let's listen to first Amelia and then Isabel, and then I will move to the last topic and go to the Q&A general. Yeah.
Okay, I'll be very, very quick. Just in answer to Simonetta's specific question, I think two very brief points. The first is that we know that GDPR hasn't been terribly well enforced. It's a very new law, but it was done on a delegated basis across the EU. And essentially that puts a lot of weight on the Irish Competition Authority to deal with big tech, and their incentives and their resources, frankly, are not really sufficient. So GDPR has an issue. Therefore, it's great if the DMA can strengthen some of the requirements on the platforms, because they might actually get enforced. But the second point is, and going to the data portability, yes, there are data portability provisions within the GDPR, but they are focused on the privacy aspect, because that's really what the GDPR is about. So they're very limited. They basically say consumers can have their data back. It doesn't say they can have it back in real time. It doesn't say that it can go directly to a third-party seller on the basis of consumers' consent. It doesn't say that that has to be on the basis of an API, consistent data format, any of those things, because it actually, for all Christina's comments about how antitrust should take GDPR, should take privacy into account, privacy people quite reasonably don't take competition into account. But data portability is both a privacy thing, but also a potentially valuable competition thing. And GDPR is not set up to deliver the competition benefits.
Next point by Isabel.
Yes, I completely agree with what has been said by Christina and Amelia, that data protection or privacy is an antitrust issue, going much beyond the fact that the consumer would not make this a relevant criteria. I think that this for us is really something that is not debated anymore. And we have, for example, the Apple iOS case I mentioned earlier, which was really about something different, about Apple deciding to protect privacy. So they were saying, and this affected the whole range of businesses. And was this an abuse of dominance? So I think that we really do not see any limitation in the type of problems that can come to us as antitrust problems. Another example, the Related Rights Directive as applied by Google. We consider this as a possible antitrust issue, even though it was the application of a specific directive concerning the rights of publishers. So maybe to answer Simonetta, I think that it will be useful to explicitly state in the DMA that there should be the possibility to ask for advice to any relevant agencies. It could be a sector regulator, but it could also be a data protection agency, and maybe other agencies that we are not thinking about right now, but that will be relevant in a few years. So I think that this is an easy thing that can be completed in the DMA, and that should be explicitly said in the next few months when we refine the text. So, and maybe the last question that was by an anonymous spectator: should the designation of gatekeeper remain enforced by the Commission or by the NCAs? I think that this is the things that should remain at the level of the European Commission, because this is not something that you can distribute at the national level. So our idea is really that NCAs could help the Commission in the application role of the DNA and the control, but not in the refining of the rules. I think that this should remain at the level of the Commission for convergence.
Thank you very much, Isabel. Thank you. So it's a great point to move to our final topic of today's panel. So we will now ask another question. So we discussed a lot about the European Commission's report DMA and also UK approach. And now we would like to compare this European approach of regulating digital platforms to the US approach. And for that, I would like to turn to Fiona And first, I want her to tell us a little bit more about these key economic principles behind the DMA and also the US approach and how they compare.
Okay, thank you very much. So when we initially put this panel together, I was going to be very boring because there was nothing to talk about in the United States. But luckily, last week, 5 bills were introduced by the House Judiciary Committee, run by Chairman Cicilline. And these 5 bills are all about regulating digital platforms. So let me talk about them. And then I'll weave them into the principles towards the end. So let me point out first that these are not laws. These are proposed laws put out by our Congress. They need to have a Senate version created, and then they need to be voted, which means that Republicans have to vote for them also. And then they would have to be signed by the president. So we're just at the first step. These 5 bills all have something to do with our topic in various amounts. So the first one, for example, provides more funding to the antitrust agencies. This is not very controversial. The second one relates to the merger conversation we had earlier on this panel. It prohibits basically all acquisitions by covered platforms, and covered platforms you should think of as being the big 4 or 5 that we've been discussing all along. And I won't talk about the definition of covered platform here, but think about the big 4 or 5, and it essentially prohibits all acquisitions there unless the parties can show no, they're not competing with the acquisition. They're not going to potentially or in the future compete with the acquisition, and there's no increase in their market position as it's now written, not market power, which is quite interesting. So I think what this does is address a little bit of what I was talking about before, which is suppose we're in a world where it's very difficult to engage in market definition, and therefore under US law where we have to do that, this creates a big hurdle for an enforcement agency. Here we have a way to prohibit all of those mergers unless the parties can affirmatively prove the opposite. Everything's going to be fine, consumers will benefit, and then the merger can go forward. So I think this switching the burden is a very good idea in this context. The third bill is about interoperability, and it mandates interoperability for covered platforms by causing the FTC to create a technical committee that has industry representatives and nonprofits on it that will determine essentially where is the key bottleneck and what should that interface look like, and prohibit the dominant firm from just changing the interface every 5 minutes, but having some process by which it's updated so that everybody can stay interconnected. Then the 4th and 5th bills are somewhat substitutes for one another. One of them says, if you run a platform, you have to be non-discriminatory with respect to the lines of business on the platform that compete with one another. So let's think about Apple and Apple Music and Spotify and Tidal. Okay, those would be businesses on the platform. Or Amazon and different batteries. The structural separation bill, the 5th one, says, if you run a platform, you simply cannot own a business that is on the platform if it generates any kind of conflict of interest. And a conflict of interest is defined as the incentive and ability to disadvantage the competitor. So again, if I'm Apple and I own Apple Music, do I have the incentive and the ability to disadvantage other music? If I am Android, do I have the incentive and the ability to disadvantage other search engines over Google search? Okay, and the answer to that second one is clearly yes, and that's what that original Google case was all about. So let me compare this to the DMA a little bit before going into principles. I would say that of course, the merger bill is far beyond the DMA. Just as we were saying, the DMA is missing this. And I think it's a very good approach, the changing of the burden. And again, the DMA, it would be great if we could have this. I think we can't, but the more we could do on this front in Europe, the better. The interoperability bill is also more than the DMA in the sense that the DMA has some specific rules like businesses should be entitled to real-time access to their own data, but that's not establishing a process by which you figure out where the interface should be for maximum entry, contestability, competition, and assign a party to monitor it, right? We don't want the dominant firm being the only one deciding what this interface looks like, because it will inevitably favor the dominant firm. So I feel that those two are actually quite good and have features to them that are better than the DMA. The structural separation bill, breaking up platforms, again, the DMA, as Monica pointed out, just has this as a kind of a last resort. And so that, in that sense, there's some similarity there. The breakup doesn't wait for something to go wrong. It says you simply can't own it. This would be the most, I think, dramatic of the 5 proposals in the United States. Now, I saved non-discrimination till last because the non-discrimination bill and the DMA are really quite similar. Indeed, the list in the non-discrimination bill under 2B of things that are not allowed that count as discrimination is remarkably similar to the list of prohibited conduct or things that you have to do under the DMA. So I think this is an area that's quite interesting to look at, and that we are going to have to spend more time doing compare and contrast and thinking about whether really they're identical or whether one side might learn from the other in the way that they are phrased. I wanted to then just turn to the underlying principles in the DMA for a minute, because I feel that this is something that really could be explained better for a couple of reasons. One, there are very good economic foundations for caring about contestability and fairness, and I'll spend a minute on those in a moment. But also, it helps you understand where the rules come from, and again, whether there is a missing rule, and if technology changes, how we might decide which rule to add. So I think this is really key. And then third, it would help other jurisdictions like the United States figure out what to do. If the senators have to now write laws, or if there's other countries that are interested in writing these types of laws, then having a conceptual underpinning is really helpful, because every country's legal system is different. So they can't simply just copy what another country is doing. They have to find a way to get there through their own legal process. So what do we think about fairness and contestability? Well, Monica alluded to some of this already. The fairness piece, you can think about in a world with network effects. When we do our economic marginal analysis, me at the margin, my contribution to a platform is pretty much zero, epsilon, because there are many other people who look like me. They can learn from those people. If I leave the platform, network effects are hardly changed at all. So in the bargain between me and the platform, I get almost nothing. But if we thought about all consumers together in the aggregate, what they care about is being together. That's what network effects are. If they move to a different platform, possibly a better one, possibly slightly worse, they would be almost exactly as well off, because they care about being together. That's what generates surplus. The platform, however, would lose everything. So in a bargaining game between all consumers and the platform, you have a very different split of surplus than when you have these individual marginal consumer by marginal consumer negotiation. If you split more by average surplus and contributions to the platform rather than marginal surplus, that would give a lot more to consumers and complementary businesses. And when people are compensated according to their contribution, we get efficiency benefits like incentives to innovate, and generally as a society, that's more fair. So that's an economic underpinning of fairness that I think is very solid and lets that be exported anywhere. Contestability, we have this notion from all these reports that Amelia and I and other people have written, we don't get very good competition. We get competition for the market instead of in the market. And the problem with that is that competition for the market doesn't work very well. Randomly, potential entrants come along at some times and not others. The antitrust authority has to protect all of those nascent entrants without knowing which ones are important, because one of them will be, but there are hundreds and hundreds potentially. And to get a good outcome, you really want to protect all of them. Then when one of them wins and we have a new monopolist, everyone has to pay the switching costs to go from the one platform to another platform. It's just generally not as good a world as competition in the market, where we have examples like cars or breakfast cereals or email, where an ISP can come in and offer me an email service, and I can connect to all my friends by email, regardless of which ISP I use. So interoperability is one way to achieve competition in the market. And multi-homing is another very popular way to achieve competition in the market, where I have multiple cars, or I use multiple car service providers like Uber and Lyft, or multiple different kinds of messaging. Anyway, there's lots of different ways to think about how to achieve competition in the market. And I think this is an economic underpinning of the DMA also, in the sense that we can use regulation, as Monica said, to competition doesn't really cover which of these forms of competition we have. It just protects whatever's there, and regulation could move us from one form of competition to another form of competition that works better for consumers. So that's a quick tour of what I think the underlying theory is for why we want regulation that helps us to achieve competition in the market, and regulation that helps us achieve a split of surplus that is more fair and therefore has efficient properties when it comes to inducing innovation and things like that. And I hope that the US regulation, I mean, these 5 bills really are regulation, they're not antitrust anymore, that these bills can help us in the United States move in that direction, and maybe other countries watching this process can think of even better ways to do this.
Thank you very much, Fiona, for this very, very informative coverage of such a recent document just released last week. Because, again, we thought that you didn't have much to say about US approach, but it turns out that US is much more radical in regulating than Europe now. They are, I think, catching up in a very radical way. I don't know whether that will pass as a law or not, but let's move to Amelia, and I want to ask her whether she wants to comment on this comparison of Europe, also European Commission and UK. We have already compared a lot, but the US approach, if you want to add on this.
No, I mean, certainly, I think it's really interesting that on the merger side, the US proposals are more extreme than the UK proposals were, in that it completely reverses the burden of proof. So the firms have to show that there is no harm to competition, and there is no potential for efficiency benefits, which is, you know, that's pretty strong. I think that there is rationale for it, given the legal framework and the problems of convincing the courts in the US, and I can see why they have to have a slightly different system there with the court-based processes compared to the UK, where it's decisions by the authorities in merger cases. But nonetheless, that seems quite strong. The rest of it, well, in particular, the non-discrimination bill and the interoperability bill, I really like. They're really the core of regulation. And I actually think that the non-discrimination bill, I think some of the clauses, a lot, as Fiona said, a lot of the clauses are very, very similar to those in the DMA, but I actually slightly prefer the wording. So I think it would be useful for the architects of the DMA now to go and look at the wording in the US and think about, you know, pros and cons. And I also think another interesting point is this separation of many of the rules and the few rules that are really about driving competition in the market, so data portability and interoperability, into a separate space, a separate bill, and treated somewhat differently. And I would just highlight that the same is true in the UK proposals. I didn't really go into this earlier, but the UK proposals, there will be a set of bespoke rules for the SMS firms, but separately to that, there will be the potential to introduce what are called pro-competitive interventions, which are exactly kind of data portability, data access, interoperability on an ongoing bespoke basis where justified by the evidence. And I think that's really quite similar. So they just work in rather different ways. They're going to need different skill sets, different approaches. And I think the US has got that. I think the UK has got that. And I think that it would be really useful for the EU to think about that as well.
Great. Thank you very much, Amelia, for adding this. So I think we have now time for our open Q&A. So, Christina, you would like to add something.
So just if you don't have anyone else jumping in, I'm happy to say something. But,
yeah, please go ahead.
So I mean, I find it very amusing how we in Europe sort of first look at the US and say, they're nowhere, eat my dust. We are ahead by years and they'll never catch up with us. And then in 1 year, the state AGs produce the Facebook complaint, Texas learns they attack and produces the Google complaint, they do the DOJ complaint, the FTC complaint, and they produce a regulation from nowhere to peak in 1 year.
I need to interject here. So first of all, let's point out that the first hearing in the Google search case will be in the fall of 2023.
But
so they take forever. And also, these 5 bills in the House are not laws. It's going to be very interesting to watch and see. But I take your point. It's exciting. Yes.
The point is that in 2019, I upset the ABA in DC because I did an event and you came in which I said, is Europe leading the way on digital regulation? And the ABA were truly upset with me because I dared to challenge the US primacy. But the point is that since then, I think that the US has moved forward a lot. That is my point. Absolutely. There's been an enormous amount of catching up. I completely agree with you that the fact that these kind of cases are going to court, Texas is going to be quicker. Huh? They don't wait around in Texas as much as in DC. But I mean, that's a difference. So there's that. So I'm full of admiration for the way in which, we look at you and we say, whoa, these Americans, when they move, no FTC chairman leader can. I mean, this isn't a joke. It is quite serious revolution that goes on all the time. So there's one point which is a bit facetious, not terribly serious. But the more serious point briefly on the substance, and again, it is so interesting I'm an outsider and sit in London. Of course, I don't tell you anything that you don't know, Fiona, but the dynamic between the various factions is extraordinarily interesting to look at because, of course, for a certain group of progressive, these bills are not per se enough. And people have been worried and complaining that actually Slade Bond and the congressional group have been listening to the rule of reason crowd far too much. And it isn't quite as per se as it should be. To my taste, I think that, although some of these are written in a way that appears to be, of course, quite radical, when you say that there is a prohibition of certain things that break up, but subject to sort of an analysis of incentive and ability, I think that makes quite a lot of sense to me because we know, and this is kind of going back to the business model point, that we cannot make the immediate and absolute assumption that any business that has got an operation on the platform inevitably and per se de facto has incentives to foreclose. We don't take that kind of assumption in vertical businesses. We always say, well, it's an empirical question. It depends, okay? Not everybody who has got an operation integrated with something is going to have incentives and ability to foreclose. So I think to preserve that is significant. So they are extreme, but they do have, at least in principle, the possibility of differentiating between business models in which if you monetize in ways that take money from both sides, you don't have the same incentives to self-preference, for example, in general. So I think that is quite remarkable, and I'll just stop there.
Can I jump in here and say what I find so remarkable about it is that the approach is so different. So in the DMA, we have this 100 pages document, and then there are these 2 articles with 18 rules. And we have been thinking for weeks now how to make sense of them and how to interpret them and what they really mean. And here comes the US proposal with 5 bills. And the important sentence is just one sentence in each of them. It's, so mergers are forbidden. And that's it. And then there is a bit of explanation of what's the covered platform, what not. But in the end, it's so extremely simple. And so it leaves you wondering whether, the exactly the rules you just talked about, the non-discrimination and the interoperability, if they are not simply sufficient to do the trick, I mean, we would, of course, now be able, I guess, to come up with some things that are not covered by them. But if we just had these two things, it would be such a difference.
So, Monica, I totally agree with the way you're thinking. I think if you have a changed burden, interoperability and non-discrimination, with these notions of incentive and ability, and this is what I was talking about at the beginning, where I find it hard to group these 18 rules, because what I think like this, I would rather have these kinds of principles and then try to, as Christina said, fit the business model in. If I'm selling something, what is my incentive? What is my ability? And if that causes a problem, then maybe we need some regulation. If it doesn't, then I don't fit the parameters of that law. So I think what you're saying is so right.
Mm-hmm. So perhaps one excuse or explanation or whatnot for the European approach might be that they are now dealing basically with the US companies, and so are always worried that it may come across as something or just against foreign companies, just protecting their own businesses. Whereas the US, well, I mean, it's their own business that they're controlling here. So perhaps they have more freedom to go after them in such a radical way. And in the end, I mean, it still has to be passed as law, I'm sure. But yeah, even if that's the explanation, I do like this US approach so much more.
I agree on this point that it's very simple, but at the same time, it leaves room for flexibility. So this incentives and ability could give a lot of flexibility to the authority, right? So it's not, they are not tying also their hands in terms of, I think that's a very clever approach. I also agree on that. So I think this is a time for our general Q&A. So I'm looking at the screen for the questions. So I have a question again from the local, Hannes Ulrich from DIW and the University of Copenhagen. He asks a question on merger policy. So how likely do you think EU law could be changed to enable the use of potential harms arguments in court, and what has to be done to get there? Maybe we can ask first to Monica, if you would like to comment on that, and then Isabel maybe, and other participants, yeah.
Sorry, I'm not sure if I'm well qualified to talk. I mean, this is now assessing probabilities, and we just discussed that before, how difficult it is to assess probabilities. I think it's at this point, I think it's really difficult to change competition law because of this unanimity that you need, and therefore I'm rather skeptical. Let's put it like that.
But I mean, can I jump in? Sorry, can I jump in? So as I said earlier, it's a question, I mean, there are two levels of discussion. Do we need to change the law, or do we need to enforce the law robustly? Because what the UK CMA is doing is enforcing robustly. They haven't kind of revolutionized the law. They brought in a slightly different standard for digital mergers. True, but it isn't what's driving the enforcement activity in mergers. There is a policy view that we've been floppy and we are going to have to be harder on this. And so we have under-enforced on potential competition. I remember the years as a consultant, which we also consulted in and said, oh, potential competition doesn't constrain anyone. You don't even need to mention it, okay? But it isn't true. And in these kind of spaces, we know that it's potential that matters. It is the reverse version of killer acquisition that matters. So in part, I think it is a matter of enforcement wielding the power you have. And I think that, I mean, the CMA and Shelley are not scared of anyone, and they are just kind of doing it. And actually, the courts in the UK are not punishing them. They were hard at the beginning, but now they're kind of going along a little bit more with the CMA. Then there is the question of changing the law and to adopt different standards. I mean, and there again, to me, there is an important question of enforcement will. in a way, because I remember very clearly one of the kind of most abiding memory during the Google Fitbit discussion, there was Shoshana Zuboff who gave a talk to the MEPs, okay, in the middle of that segment. And she said something that was entirely spellbinding. She gave a talk to all these assorted MEPs and said, if what is preventing the European Commission right now to block this deal is that there isn't quite an appropriate law that they feel they can do it under, you should all stop listening to me and file into that chamber and vote a law that will allow them to do that, because this is the more important thing that you should be doing right now. So the point is, I understand that for an institution, it is hard to lose in court. And I don't want to belittle or minimize that. Of course, an institution has problems of morale, of perception, of standing. But in a way, I wish that the Commission said, we're going to just go and lose. And after we lose, we'll argue that we need to change the law, because clearly this isn't going to work going forward. So I think there is an important matter of, and who am I to say? I'm an outsider, and of course I don't live inside an institution, but I'd like to see this kind of power being wielded in a way that's effective. And my model is that some agencies like France, like the UK, like Germany do. So I think we can do that for merger control.
Can I just say one thing in response to that, which is, I mentioned it earlier, but there's been a case that a big merger called Hutchinson O2, a 4-3 mobile telephony case, so kind of not the topic of today, where the Commission blocked it. It got appealed, and at least the General Court, it's on further appeal. So hopefully this will get overturned. But the General Court has basically told the Commission they got it all wrong. I'm sure there are things in there that the Commission did get wrong, but they've also in the process basically set the standard for intervention at an almost impossibly high level if you are relying on economics, because economics just doesn't give you ever the level of certainty that they're requiring to block a merger. And actually, I think that the EU's got itself in a right old mess. And if that doesn't get sorted out, you know, we have a really, really serious problem.
I agree.
All mergers.
Totally agree. Totally agree. That has been a total shot in the foot in a way, in that, you know, that is paralyzing, that loss in court. Totally paralyzing, but also, you know, but what's going to break that? You know, it's not like, you know, I think one needs to be, I mean, Bill Kovacic keeps saying, we lost in court, we lost in court, we lost in court, and it kept going, and it just kind of gave us the energy to do things more.
Enough proof, maybe. So that can.
I think all of that, everyone in this Zoom call, 48 participants, should all write a big letter to the courts and the ECJ, and basically say, get it right on appeal.
Get with the program.
Indeed, Amelia, we have more people watching us live.
Okay.
But they are not in the Zoom call. So I think we have around 200 or something like that live watching us. So what you said also applies to them. So they should exactly follow the suite. I have a question on the US approach, because I was very much fascinated by this fourth rule, basically banning these hybrid platforms business models if we can show incentives and ability to harm. Because when I think about vertical mergers, there was a justification for efficiency defense. And in a sense, I see, you know, the Amazon is vertically integrated in its own product, but at the same time, there is a crucial difference, which is that running the marketplace is not the same as just selling the input to the rival. So it's a little bit different too. So I want to ask your opinion about how different, why we shouldn't allow for efficiency defense. Is it something crazy to think about? Or I find it very radical in the sense, because usually vertical mergers are always, you know, supported if there is efficiency defense, but this case is strictly banning hybrid platform just based on incentives and ability, even if it might be efficient?
Yeah, I think this goes back to the political economy and the way our courts are set up in the United States. We have very conservative courts. We have great fluctuation in technological change and in the way products compete with one another and evolve and grow. And the result of that is, and large profits at stake with the firms that we're talking about. So when you think about the financial incentive for that platform to spend money to tell the story of their efficiency defense, there's a lot of zeros in that financial incentive. And given the lack of technological understanding of the court and the economists and everybody, they can effectively tell, colloquially, I would say, they can kind of make the story up that they want to and find a way to support it because there's so much asymmetric information and so much money involved. Mm-hmm. And the result of that is, and if you have a judge that's looking for that and ready to hang the case on that, then the government will always lose. So I think that's the reason that the efficiency defense is not in the law, is that the assumption really is, if you were to put that in, the law would become empty and would achieve nothing. And while as economists in a perfect world, if any of us were, adding up the numbers and we were being very neutral and careful, we would want that efficiency defense in there. In practice in the United States today, we can't really have it, or the law just won't work.
Mm-hmm. A question related to a little bit on this point of vertical separation. But now it's not about vertical separation, but think about Apple. So Apple has this Apple Watch, so it gets all the data. So we discussed this Google Fitbit merger case, and Google potentially acquiring data of Fitbit users and using it for all purposes, both in the entering a healthcare market, etc. But Apple already is kind of integrated in this world, and it has already invested in the healthcare market significantly. So would then one think about also separation of Apple using its data from Apple Watch for its own purposes? I know that Apple's business model has not been ad-based business model, but they are also moving to changing it, right? So they are going towards a little bit, banning cookies and in the App Store, so they do not allow apps to collect cookies, and they are entering into heavily mobile advertising market. So I'm just curious about your, thoughts about this moving from device finance to ad finance structure, and how should we approach a firm like Apple?
You can't ask that question with only 3 minutes left in the seminar, because that is a really hard question and a really long question.
I agree.
I'm just joking. I'm sorry. I just meant it really is.
I was just fascinated. This is something that's happening, so dynamics. But feel free to not answer and say it's too hard to answer in.
Well, I think in 10 seconds it's very hard. But I mean, nothing is set in stone. If we have a concern with ad-funded businesses, then we have a concern with ad-funded businesses and their incentives. So if business models shift from something which is device-funded to ad-funded, then I have a problem. Not a big deal. I mean, in the sense that one needs to see what's happening. And if the business is moving towards an ad-funded one, then there is possibly a problem that one needs to look into. I don't think that we need to be too concerned about the consistency there. I mean, we may not have such a problem with device-funded. We have a bigger problem with ad-funded. And then if the business model moves from A to B, then our concerns develop.
Okay, thank you. I think we have to close now because Isabel has to leave, and I want to say thank you to all of you.
To rush anything. If you want to go on, I can leave.
Before you leave, I would like to say thank you very much to all of you, to all the panelists, and also all the people connected via Zoom or watching us live, being here. It was an excellent discussion. I enjoyed it so much. So thank you again for this very structured contributions and addressing these tough questions. And I think we have more to discuss given this US regulation just introduced proposal, basically. Thank you, and also thank you BCCP for the organization. And Pauline wants to add something. Oh no.
But actually, I don't think I have to add much. I just wanted to thank again the fantastic set of panelists we had here today for this insightful, to the point, and yet passionate discussion. And also a big thank you to Özlem for agreeing to lead us through the discussion. Of course, there's also a local organizing team behind that you don't see. So a big thank you goes also to all the people in the room. So Leonie, Christiane, Vladimir, Hannes, Jonas. So without you, this would not have been possible. And I wanted to say one word. So even though it was very nice to meet all of you in the virtual space, we hope very much that we will see you next year in person at our conference in Berlin. And it will continue to be on the topic of regulatory challenges in digital markets, but we want to change the format a bit to give the floor also to junior researchers. So in addition to the policy panel and keynote speeches, we want to give the opportunity to junior researchers to present their work on topics in the area of digitization. So we hope to see many of you next summer in Berlin, and thank you very much again for joining us today.
Thank you. Bye-bye.
Bye-bye.
Thank you. Bye-bye. Seeing you all. Bye-bye.